talk about that standard as Alabama's. That's straight out of Atkins, isn't it?
It's straight out of the Alabama statute.
Also straight out of Atkins, isn't it? And Hall and Moore.
Atkins.
You say it's at the same standard everybody except for Oklahoma uses it. So
Oklahoma
they all use it for a reason because it came out of our decisions, right?
Well, no, the reason it came out of Atkins was Atkins found that there was unanimity among the expert practitioners and associations.
Oh, fine. Whether the chicken or the egg came first, it's in Atkins.
We're in violent agreement.
All right, thank you.
Counsel, Mr. Waxman, I don't do this often, but Justice Gorsuch set out a statement that he asked the other side whether it was a holding that they disagreed with. You read something.
I did.
Yes, you did.
You want me to read it again?
Please, because I'd like Mr. Waxman.
I don't remember it, so I appreciate it.
And I took it down and I can't find my notes now. So could you please, if you do that.
I would be delighted.
Thank you.
The question is just how to understand, which I've struggled with, both Moore and Hall. And I read Hall as saying that you cannot treat a single score in the low 70s as decisive. And I read Moore as saying you can't use facts extraneous to IQ to outweigh a low score. Fair?
Fair with the caveat that extraneous to IQ. Well, no.
I mean, that's what the court did.
If what you mean is extraneous to the question of what his true intellectual functioning is,
no.
yes.
Yeah, it started looking at things to try to outweigh a low score. It started grabbing at other facts.
Well, it not only, I think it would be a due process violation for a court to say the evidence on the test scores is inconclusive, but I'm not going to let either the state or the defense put on evidence. I mean, this court has Washington versus Texas and Crane versus Kentucky and any number of other cases basically stands for the proposition that you can't artificially limit presentation of evidence that is relevant, probative, and admissible.
In Moore, counsel, the two scores were 74 and 78. And the court, and we held, the state court violated Hall when it discounted the lower end of the SEM because he was, quote, malingering. There we held that when there's an IQ below 70 with the SEM that adjusted for this test standard error, then you must permit evidence of whether clinically he falls within the range of intellectual functioning details, correct?
That is a correct holding, and my understanding of the disagreement between the majority and the dissent was leaving aside the Briseno factors, whether a district judge committed clear error in determining the issue the way it did.
And so Justice Gorsuch's second reading is wrong. We do require clinical evidence, but the finder of fact could rightly not be persuaded by it, or it could be persuaded by it. That's your point, isn't it?
That's correct, unless the court concludes that I've got, let's make it now 10 IQ test scores, all of which both experts agree were properly administered and reliable. And in light of that finding, one test score of 70, there is no evidence other than the testimony of the experts that could change my mind that he has not met prong one.
But
and
that's not the case here.
I mean, we're not in the same time zone as that.
No, because we have 3 tests, all of them.
4.
4, all of them within the SEM. He could be 70 or below.
He could, and he in fact demonstrated by a preponderance that he is.
And in fact, Dr. King, whom they rely upon, the petitioners, testified that the scores were within intellectual disability, but then he went to other factors to say why he thought he was functioning within.
Well, I think Dr. King's testimony will stand for itself. The district court found his testimony to be less credible than the other experts. What he said is, We have 5 scores, and they're all above 70. 4 of them, looking at the individual standard error of measurement, are within the range. But he was asked a question by the prosecutor, are you aware of a theory by Dr. Flynn that when there are multiple test scores that are close together, the standard error of measurement will be reduced? And he said, yes, I'm aware of that. There was no testimony about what, in this case, that standard error of measurement would be, and it is inconsistent, flatly inconsistent, with what this court said in Hall and what, in at least 5 cases, Alabama courts have done, which is always apply plus or minus 5.
And in
Thank
fact,
you, counsel.
they've
Thank you.
rejected Flynn, correct?
I'm sorry.
The district court rejected the Flynn effect in this case.
Yes, we're not relying on the Flynn effect.
Thank you, counsel.
Thank you.